A century after women secured their right to vote in the U.S., a long legal battle may be on the way over another constitutional amendment. Virginia just became the 38th state to pass the Equal Rights Amendment.
The Equal Rights Amendment is meant to constitutionally prohibit discrimination based on sex, but it never received the 3/4 majority needed for ratification until now. CBS News chief legal correspondent Jan Crawford explains why some opponents argue the move still comes too late.
For the women of Virginia and the women of America, the resolution has finally passed.
These votes Wednesday in the Virginia House.
Senate Joint Resolution 1 is agreed to.
And Senate were celebrated as a possible turning point by ERA supporters like Donna Gransky, who's been fighting for the amendment since the 1970s.
The only way that we can guarantee gender equality is for it to be enshrined in the United States Constitution. That's what today means to me.
The fight over the ERA started in 1972 after Congress approved language that, if passed by 3/4 of state legislatures, would amend the Constitution to guarantee that rights under the law shall not be denied or abridged on account of sex.
I spoke out on this important issue because of my deep personal convictions.
With support from high-profile Republicans like First Lady Betty Ford. And large demonstrations by supporters of the women's movement. 35 of the required 38 states passed the amendment in just 5 years. But the effort stalled when conservative lawyer Phyllis Schlafly launched an anti-ERA movement.
And you've got to be kidding to say we should support something that would require our daughters to be in combat in the next war.
A 1982 deadline for ratifying the ERA came and went, and the effort appeared over.
The chimes strike at midnight for ratification of the Equal Rights Amendment. At that moment, the ERA becomes DOA.
Now, more than 4 decades later, supporters have revived the amendment. But opponents like Anne Schlafly Corey say her mother's arguments remain valid.
It will cause harms to women in all kinds of other areas without giving them any benefit.
In Virginia, supporters made the fight about the next generation.
It was just very empowering to see it get passed and to see that I could have an equal future.
All right, with more on what we can expect next, Jan Crawford joins us now from Washington. So Jan, walk us through what the immediate next steps look like.
Well, there's still another series of votes in Virginia. It's considered a formality. And then it looks like it's going to end up in court, where that's going to be a huge battle, because the question is that 1982 congressional deadline. And are the supporters of the ERA able to count the 35 states that passed this Equal Rights Amendment before that deadline, in addition to the ones that have now just passed it, to get to the magic number 38 that's needed to change the Constitution?
So just last week, the Justice Department's Office of Legal Counsel published an opinion stating that the deadline to ratify the ERA has expired and is no longer pending before the states. Explain what that means and just how does that complicate matters?
Well, some of the state attorneys generals had asked for some guidance on what to do and how they should handle the different votes in some of the states that we've seen recently. And so they got this opinion from the Justice Department legal team there in the Office of Legal Counsel. Those generally have a lot of weight in the courts. And as you saw from our piece, it was widely understood back in 1982 that this was over, that the deadline meant something. And that the supporters of the Equal Rights Amendment had failed. So now the question is, are the courts going to step in and say, well, that 1982 deadline is binding, it wasn't part of the original language that Congress passed, a lot of different legal arguments there. So are they going to step in and say, that deadline is not binding? You can count the 35 states that had passed it before 1982, add those to the 3 that have passed it recently, and voila, you're at 38. Opponents are going to say, no, you don't get to count those 35 states. You got to start all over in Congress with new language that then would go to the states and start the whole process all over again. Of course, it's a very different time now than it was in 1972. So, that may be the route that they end up going.
All right. So, Jan, could we see this fight end up at the Supreme Court?
Yes, it could. Eventually, depending on how it plays out in the lower courts. If there's a conflict in the lower courts, just because it's a weighty legal issue doesn't mean that the Supreme Court's going to step in. Generally, they will resolve conflicts, issues of dispute in the courts below. So sure, there's always a possibility that this could get kicked up to the big guys in the Supreme Court, but I think that's way too early to say. There is a long legal battle ahead right now.
So then ultimately, could this be more of a symbolic measure than anything that actually results in some serious, any sort of change, a change to the Constitution?
No. Yes and no. Yes, this could be a symbolic measure in Virginia as a message to say we need to do this now. And that could kickstart a movement to do this now. So whether or not just because it may be symbolic doesn't mean it might ultimately have an impact on changing the Constitution, if that makes sense.
Yeah.
So it's
Makes complete sense.
Yeah, it really does. Jan, thank you so much. Appreciate it as always.
Sure.
And tonight on Red and Blue, Julie Suk takes a closer look at the long road ahead for the ERA. She's Dean for Master's Programs and a Professor of Sociology at CUNY. That's the City College of New York. You can take that stream and that conversation in our 5 p.m. hour.